Good evening.
Good evening.
Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth?
I do.
And if you would state your name and address for the record, please.
Linda Redding, 10450 Oxcart Lane, Nanjemoy, Maryland.
And Ms. Redding, just to make it clear from the outset, you are not...
Mr. Wolfgang, can I ask you to get real close to a microphone, please?
Yeah, Ms. Redding, you are not an adjacent property holder, are you?
That's correct.
And how far away is your property?
As the crow flies, I guess about a mile.
And what is your interest then in this property?
First would be safety, and then the second would be property damage.
Okay. So, first let me direct your attention to the exhibits that we provided. That would be exhibit, let's start with exhibit 3. And that is the
Potomac Heritage Trail on-road bicycling route.
And tell us what the Potomac Heritage bicycling route is to your knowledge and understanding.
Well, I know these roads, and as Molly testified before me, that there's a lot of bicycle traffic. So I found if you go on the National Park Service website, these roads are actually part of a Potomac Heritage National Scenic Trail, and there are bicyclists on it. It seems like all the time.
And do you travel both Adams Willett and Hancock Run Road on a regular basis?
Yes. Hancock Run Road is, in essence, a shortcut for people who live in my area of Nanjemoy to get to the only store in Nanjemoy or to get to Mallows Bay.
Okay. And just in case the members of the board don't know, where is the only store in Nanjemoy?
It's on Liverpool Point Road.
And is it far away from the intersection of Liverpool Point and Adams Willett Road?
Not terribly. If you take Hancock Run, bend around, and go on to Adams Willett, when you come to Liverpool, you make a left, and I guess it's about a country mile down on the right.
Okay. So, do you have any other reason that you travel Hancock Run and Adams Willett on a regular basis?
Not other to get from point A to point B, as the store and Mallows.
Okay. And if you're going to Mallows Bay, where do you go when you get to Liverpool Point Road?
You'd have to make a left on Liverpool Point.
All right. And Mallows Bay is a state park, is that right?
It's a national marine sanctuary.
Marine sanctuary.
You see it in the Post and in magazines. It's garnering a lot of attention.
And what takes you to Mallows Bay?
Kayaking in the old shipyard there.
Okay. So, you also indicated that you were concerned about erosion, is that correct?
Yes, my property is on Nanjemoy Creek, and any increase in impervious surface, replacing the forest with impervious surface, and particularly in this magnitude, will assure increased stream bank erosion and sedimentation of the creeks and the stream bank erosion of my property.
Hancock Run is fair to say that is the waterway that will take runoff away from the subject property?
Correct, into Nanjemoy Creek.
Okay. So do you know where Hancock Run joins with Nanjemoy Creek?
It is after it crosses Hancock Run. It's not visible on the map here, but it's after it crosses Hancock Run Road in the forest there, and then it turns and crosses Route 6 before it, when it becomes Nanjemoy Creek, it crosses Route 6.
And where Nanjemoy Creek crosses Route 6, is there a bridge there?
There is.
To your knowledge, is there any other stream that feeds into Nanjemoy Creek up above the Route 6 bridge?
There could be some unnamed tributaries.
Is it fair to say that Hancock Run is the largest?
It's the major tributary, yeah.
So, have you ever had any problems associated with flooding of Nanjemoy Creek at that bridge at Route 6 just below Grayton?
Absolutely. Yes, I do have had.
Stop.
I object. May I be heard?
Yes.
The board's counsel sent out a letter in advance of this hearing indicating that the petition of appeal or letter of appeal stated the issues that were to be litigated before this board in the appellant's appeal of the Planning Commission approval of the preliminary plan. Mm-hmm. Those issues were outlined by counsel initially. 2 procedural issues before the Planning Commission. One dealing with a continuance, the other dealing with public participation. Mm-hmm. And the third issue had to do with roads. Mm-hmm. This testimony is not relevant to any issue that's been raised in the petition of appeal. And as this board has already ruled, the testimony in this case is limited, or as your counsel has indicated, I should say. Well, the testimony is limited to the issues that have been raised in the petition.
Your co-counsel has asked questions relating to how witnesses' properties may be impacted by this development. So I feel like he's kind of opened the door for that kind of testimony.
He's not my co-counsel.
You've invited him to appear on your behalf.
Mr. Mudd?
Yes.
Absolutely not. That is incorrect, sir. I'm here on behalf of the county staff,
right.
The zoning officer. The applicant has their independent counsel and their independent basis. Right. My role here is not to further the application of the applicant in any respect. My role here is to present the testimony of the staff in support of its recommendation and in support of the Planning Commission's decision based on its recommendation. I'm not here to defend any aspect of the applicant.
Okay.
And I believe that the applicant's counsel hasn't, by asking questions that relate to standing, has not broadened the petition of appeal. I think this board's counsel was correct. In fact, this board rules specifically provide that the reasons in support of an appeal must be stated in the petition
right.
of appeal.
Okay. I'll ask for some input from our counsel here.
Should I be heard before that, sir? Do you think that's more appropriate, or? In other words, I think he
objected. You can respond first. Yes, go ahead.
I think you'd want your counsel to respond to what I say, right?
Yep, go ahead.
As far as I am concerned, and we have been down this road before, this is a de novo proceeding in which we are showing you not just the problems that allow us to make an appeal of this case, the errors that were made down below, but also setting the stage for all of the decision making that this body can and should and will do in according to its rules, substituting its judgment and using the power, the exact same power that the Planning Commission had in terms of its ability to deny or affirm or affirm in part the decisions that were made, but do so on a de novo basis. That's the first response. And the second response is, in fact, that I do need to be given the opportunity to show how the individual testifying is uniquely affected by the subdivision as you indicated, having to do with standing. Obviously, that's an issue. It may not be an issue for this board, but when this record is taken up to the circuit court, that will be an issue, and the issue will be on the record made in this case.
Mr. Meacham.
Under Rule 10, Administrative Appeals, it stated that an appeal is taken by filing a written notice of appeal with the zoning officer and the board specifying the grounds therefor. So it would seem that if there's a requirement that the grounds of the appeal are specified, and remember, there's no limitation. There could be theoretically pages and pages of grounds for the basis of the appeal. It would seem perhaps contrary to that requirement to then allow different grounds or more grounds to be advanced in the course of a hearing. Also, as was referenced by Mr. Fisher, a letter did go out from me at your request instruction setting forth what the issues would be, and there was no objection raised at that time. And it would seem that it's not clear, I guess, what the relevancy of the testimony would be, because if you can only use the grounds that were specified in the notice of appeal and nothing else, then how are you all as the board served by listening to evidence that's outside of what the reasons advanced for the appeal are? And for as a matter of standing procedurally, I believe that if that's raised at the court level, the court has the authority to conduct a factual hearing with any of the parties, and at that time that issue can be fleshed out factually.
Sir, I just would like to say that all of that misses the point of the process that is specified in your rules for determination of whether a hearing is going to be on the record below or de novo. And specifically, the case is to be de novo unless all of the evidence that is necessary for determination by this board is already on the record in front of the Planning Commission. Well, our one of the key points of our appeal is that information is not on the record down below. It's not on the record down below because individual citizens were not allowed to testify down below, and also because things having to do with the roads were not considered down below, and therefore it didn't become testimony or evidence down below. And so that then creates a trigger for this case to go over into the de novo category. And when it's de novo, that means we have to prove our entire case. That's what we're doing. And we're laying an entire case against this subdivision as opposed to being limited to those individual trigger points that are in the appeal.
May I respond to that, briefly?
Sure.
I think counsel is misstating what the concept of de novo means.
If you could speak up a little bit.
Sure, certainly. Counsel is misstating the concept of de novo and what that means. The issues before this board have to be stated, as your counsel has advised you, in the petition of appeal. That is true of virtually every board of appeals and tax court and every administrative agency that sits at an appellate level. What the de novo standard does, it doesn't broaden the issues that are before this board as stated in the petition. What de novo refers to is the standard of review of the appellate authority. De novo review differs from the deferential review that a court would apply to factual findings of this board, for example. When a court reviews this board, it will review your factual conclusions for substantial evidence. It will review your reasoning to determine whether it's arbitrary and capricious, and it will review your legal conclusions de novo. It will substitute its judgment. This board has authority because it sits as an administrative agency and not as a court. Under the statute and under the county public local law in the county code, this board has authority to make de novo factual findings. In other words, you are not required to defer to any factual conclusions of the Planning Commission. Having said that, that does not mean that de novo means you don't have to properly prepare a petition of appeal and you can come in and raise any issue you want. What it means is that when you raise an issue in connection with roads, that this board has de novo authority to make its findings in connection with the issues raised as to roads. Thank you, and I appreciate your patience, Your Honor.
Can I